a place to live until she gets married. So that's a positive thing, as opposed to a negative, you can never marry, all right? So right now, that condition is actually okay. Eventually, we're going to figure out that's really the same, and this is not as sexist of a place as it used to be, so we're just going to erase that as well, and she'll own it free and clear. But in the meantime, that's a legitimate, not against public policy restriction. You can have it until you marry, because it's giving a positive thing. Lots of people, when they grant property to county for a park, it says you can only use it as long as it's a park. Okay? That's a pretty severe restriction. Only use it as a park, but we want to encourage parks, so that's okay. One of my favorites is a hospital. Hospitals are good things. We like them around, and so we allow a restriction in a deed that says you can have this property only as long as it's used as a hospital. If it ever stops using it as a hospital, you lose your right to the property. That's okay because we want to encourage hospitals. Yeah?
So then you'd also need to provide what would happen should it not be used as a hospital.
It goes back to the grantor. That's the...
Like in the case of the woman, until she gets married, would it then maybe go to the children?
It goes to the children. That's exactly right. It goes to his heirs because he retained those sticks. In the case of the hospital, it's a perfect example. I actually just dealt with this one fairly recently. There's a hospital in Vancouver, Washington that had been there since the 30s. And they've since moved the location, and they still have some sort of hospital stuff going on there, but it's not the main hospital anymore. And they wanted to sell that property, and its highest and best use was to be bulldozed and built up with houses. But there were some deed restrictions on those properties that said only as long as it's used as a hospital. Clear back from the 30s. The person who retained the sticks, as it were, who sold the property and said, if it ever stops being used as a hospital, it comes back to me, he actually sold those sticks for $2,000. There was a deed in the deed records that said he sold his interest for $2,000 to an individual. That individual later died, and we found their 4 heirs. Okay? And those 4 heirs owned those sticks. The hospital wanted to sell that property, take the money, and build a whole other building at their new campus. So they had a really good reason for doing it. So I went to those 4 heirs and said, the hospital would like to buy your sticks, because we can't take them back. We can't change the use of the property otherwise. They own those. So we went to them. Fortunately, they were wealthy and nice. Okay? Not often do you get both those things together. All right? You get some nice people who aren't wealthy, and you get some wealthy people who aren't nice, but we had them both. In this case, those 4 people said, you know, that's fine. You can just have the sticks back. And they gave them back to the hospital, who was then able to sell that property and use the money to build another building. But that was a condition that we deem important enough to allow, even though it's a pretty severe restriction. We mentioned earlier assignments and trust deeds, and we were talking about the short sales. That is a restriction, because what it is it says that if you sell the property or any interest in it, it's a default. Okay? That's a real restriction on the property. It's telling someone they can't sell their property unless they pay you back. But the bank had really good lobbies when they passed these laws. And so it's not against public policy to restrict assignment of a piece of property. On the other hand, I can't sell Jane my property and tell her she can never sell it. Okay? That's an unreasonable restraint on alienation. I've seen a couple other good ones as properties were appreciating, and I won't see this nearly as much as I did before, but I saw sellers who, when they sold their property, said, if you sell this property, then I get a portion of the profits. How's that for a nifty deal?
Well,
Yeah.
isn't that how they put together these, what are they, land trust things that allow people to get into low income home ownership, but it's a shared equity that goes back to the nonprofit that controls the land.
And that would be okay because that's clearly for the public policy of getting people into home ownership. But what if I'm a developer and I want to restrict someone from profiting off of the property that I'm selling them? Essentially, I've seen people prevent flips, say you can't sell this for a year. You can buy this, but you can't sell it for a year. That's probably okay. Where the seller's going to get a share of the profits, I don't know. Is it reasonable or not? And sell it in the next 6 months, I get a share of the profits. Okay, and there's people doing that. And the reason why they're doing that, there's a neighborhood in Portland called Eastmoreland. And a couple of years ago in Eastmoreland, properties were going up 27% per quarter, 3 quarters in a row. People were flipping properties in 2 weeks. You know, they'd buy it, and next month it was worth, you know, however much more. I mean, 27% a quarter these properties were going up. And so that's when sellers started thinking, well, gosh, I'm going to make some money selling it, but if they sell it again, I want to share that. And I'm not so sure if those actually work. We'll see. My favorite one I've seen is a broker Broker sold a piece of property and said, if you sell the property, you have to list it with me. That was in the deed. That was in the deed. That one's not going to work. That one's not going to work.
Isn't that basically what farm home used to have?
I don't know.
When you sold a farm home, when you had bought a property, it was financed with farm home. When you sold it, you gave a portion back to farm home.
I've not seen that, but I wouldn't be surprised.
No, it's like a habitat thing.
Yeah,
I have a
yeah,
question.
sure.
Does the discrimination specifically address homosexuals?
Does not. You can discriminate. Actually, I just want you to know to start out, the shorter the rule, the more the exceptions, all right? This is a rule. You can discriminate, okay? Short rule, you can discriminate. The longer exceptions are, there's some places where you can't discriminate, all right? And the list for property is color, race, religion, national origin, handicap, all right? Those we've established. There will be others, but they're not all there yet, all right? So if you saw a deed restriction that said you can't own this property if you're gay, all right? Right now, that's not on the list. Now, I wouldn't expect that. See, it doesn't say, that list I read you doesn't say sexual preference, okay? So, now, there are some laws, like the city of Portland said you can't discriminate on things like that, and eventually, it's going to get added to the list. That list is going to have one more. Very soon, I would expect you're going to see sexual preference listed on there as well. It's the way it's going to be. So,
Probably worded like legal sexual preference.
well, and we're going to talk about domestic partnerships as well, because those tie into how people take title to property. It's becoming more common. So next I want to talk about the concurrent estates. Concurrent estates mean when two or more people own a piece of property, when they're sharing that bundle of sticks. How is it that they own it? The most common type is, well, actually I wouldn't say the most common type. The most common type I see is tenancy in common. That's when two or more people who aren't married, okay, own a piece of property. Tenancy in common is if Jane and I, who are not married, were buying a rental house, all right? The presumption is when you deed to two people that it's going to be tenancy in common. You don't have to say anything in the deed. If the deed says to Jane and Jim, all right, then we own as tenants in common, even though we didn't say as tenants in common. We could. The usual language you see, though, is it would say to Jane an undivided 1/2 interest and to Jim an undivided 1/2 interest. Okay? That language tells you that it's a tenancy in common. It could say to Jane a 40% undivided interest and to Jim a 60% undivided interest, which I like that one much better. And that's then, we own it as tenants in common. And that's the presumption. It's called an undivided interest, but it's actually a divided interest. I think we just give that language to confuse people, because it's really quite divided. When you own a tenancy in common, and I say it's divided because you can separately sell it. Jane could sell her tenancy in common interest separate from mine. I'd still own mine, and whoever she sold it to, I'd own the property with, okay? Because it's separately sellable. It's separately mortgageable, which sounds silly. Why would a lender only loan on half piece of property? But where I see it is where a lender is making a balloon loan to somebody, and they're securing a bunch of different properties that they own. And so they'll take a security interest in even a tenancy in common. It's inheritable. So if I were to die, my interest would go to my heirs. Jane would still own her 40%, but my heirs would get 60% without her consent or without anything. So that's how a tenancy in common works. I recommend, so if you get a boyfriend or girlfriend buying a house, okay, they can't buy it as husband and wife because they aren't, so they're buying as tenants in common. I recommend, or even if it's just Jane and I, we're great buddies and we're going to buy a rental house together, I still recommend to everybody buying a house as tenants in common that they hire a lawyer, first of all, because I think people should always hire lawyers, but hire them to draft a tenancy in common agreement, okay? A tenancy in common agreement looks a lot like a partnership agreement, but it's not, because we're not partners. We each own an undivided interest in this property. We're not partners, but we want to be able to set it up so that if she and I no longer like each other, we can deal with how we're going to sell it or how we're going to buy each other out. Or what if I die, and I'm not married, but let's say I was, and Jane hates my wife, okay? All right? But now they own the property together. How do you deal with that? It would give Jane an opportunity to buy out that interest from whoever was inheriting it. So it lets you deal with those kind of situations. Take boyfriend and girlfriend, for instance. There is no better time to have a tenancy in common agreement, all right? Most people who are married get divorced, which means most people who are just boyfriend and girlfriend are going to break up. It's just what's going to happen. And when they do, they're not going to like each other anymore. And they're both going to be on the mortgage, and they're both going to have this house. And how do you deal with it, all right? I mean, it's a hassle. And if you have a tenancy in common agreement, while they're all happy and together, they sign a tenancy in common agreement on how to deal with it when they don't get along, it's so much easier. You spend $600 or $800 with a lawyer drafting up a tenancy in common agreement as opposed to $5 or $10 grand when you don't get along anymore. I think it's very important. So the next type of ownership is tenants by the entirety. This is when husband and wife own a piece of property. When a husband and wife own a piece of property, the presumption is that they took as tenants by the entirety. They could take as tenants in common, but because they're husband and wife, you'd have to say on the deed, you know, Bob and Mary as husband and wife, but taking title as tenants in common, because otherwise the presumption is they take as tenants by the entirety. They don't have to, it's just the presumption. So the way we designate it on a deed is we usually just say husband and wife. Okay, that's enough. It tells people they're married, so then the presumption is tenants by the entirety. Sometimes we put in the deed tenants by the entirety. Okay, that's what I'd do as a lawyer, because more words, more pay. Okay, he would say to Bob and Mary, husband and wife, that's tenants by the entirety. There's more words. The county likes it too, because sometimes it makes more pages and they get more off the recording. So, tenants by the entirety, they both own the whole thing. Okay, so I'll use the board for a moment. Let's say this is the piece of property. The husband and the wife own the property. Okay, husband dies. Husband's gone. Wife still owns the whole thing. Isn't it funny how that works? That's tenants by the entirety. There's no transfer. There's nothing that needs to happen. It happens by operation of law. When the husband died, automatically, the wife still owned the whole thing. There was no transfer that had to happen. So that's how it works upon their death, because they both own the whole thing. Because they both own the whole thing, they both have to sign to mortgage the property. They both have to sign to sell the property. They both have to sign to do anything with the property, which is why in those situations I mentioned earlier where we have a judicial foreclosure, because the wife hadn't signed either of those trustees. And so we couldn't foreclose out her interest because she hadn't granted her interest. So anyway, that's basically how tenants by the entirety work. Now, sorry?
Why did we also see in the deed then, not as tenants in common, but with right of survivorship?
That's like I just paid you to get to right where I'm next to. No, that's where I am next. It's exactly, that's called an Erickson estate. It's exactly what I was getting to next. Actually, I'll go back for a moment. Before I get to Erickson estates, let's say a boyfriend and girlfriend buy a piece of property and then they get married. Okay, what happens? Nothing. They still own it as tenants in common because they weren't married when they took title. So if one of them dies, okay, the wife or the husband doesn't get the property. It goes to the heirs. If they don't have a will yet, which is often the case with newlyweds, they haven't put together wills giving each other's property to each other, then it's going to go to, well, their children if they had any, but if they don't, it goes to their parents. How many people get along with their in-laws that well that they want to own a house with them? Yeah?
I'm confused, I guess. You say that if somebody buys a property and gets married, the partner still owns half. One to buy, two to sell, right? Does that have to be recorded under both names?
Well, I'm saying they both buy it under their own name. They both buy it in their name. So a boyfriend and girlfriend buy a house. It's in both of their names. Okay? So it's in Bob's and Jane's name.
Oh, they have to buy it together at the same time.
For them to have an interest together, yes, absolutely. So it's in Bob's and Jane's name when they buy. They're not married, so they only took title as tenants in common because they're not married. They can't be tenants by the entirety unless they're married. All right? So then they get married. Nothing's changed in their ownership of the property. It was tenants in common before. The way they fix that is they deed it to themselves. Bob and Jane as tenants in common, deed to Bob and Jane as husband and wife. Now they've created tenants by the entirety. I've seen situations where people in a deed say to Bob and Jane, husband and wife, and they're not married. Can't be tenants by the entirety because they're not married. They own as tenants in common. No matter what they intended, you have to be husband and wife to own this property.
Can a husband and wife own it in common?
Absolutely. Husband and wife can be tenants in common.
I mean, yeah.
But they have to say it in the deed to rebut the presumption. It would say to Bob and Jane, husband and wife, but as tenants in common, because that rebuts the presumption of tenants by the entirety. So what do you do with domestic partnerships? because you know we've got domestic partnerships, all right? The domestic partnership law was passed in a bit of a hurry, and they hadn't hired a real estate lawyer. There was a problem. And I'm not saying the law wasn't done well, it just wasn't done well enough. Because it said that domestic partners will be treated as if they were married, okay? Which is great. They go down to the courthouse, they get or the city hall, and they get a certificate that says that they're registered domestic partners. And it gives them certain rights to different things.
How do they put husband and wife on there?
Huh?
How do they put husband and wife
They
on
can't,
there?
because they're not husband and wife. Can't do it. It gets a little bit interesting when they take title to property, though. And that's where we have an issue. I think it's great that we'll get people who are domestic partners come in and they want the deed to say as domestic partners, which, by the way, I don't even know this, but domestic partners, you have to be the same sex. I thought that was one of the things wrong with that law. Isn't that kind of discriminating?
Not in California, they just passed that last year.
Well, but that's in California. This is in Oregon. So it doesn't matter what they pass in California. This is Oregon, all right? You can have gay marriage in you can go to British Columbia, but that doesn't mean, you can. So it kind of depends on what they're doing. But it says domestic partners have to be the same sex. I actually think they should change that.
Yeah, they should.
I think that would be more fair.
My husband and I didn't get married for 7 years.
But you could have been registered domestic partners. Actually, you couldn't because the law doesn't allow that. Yeah. Okay, but it doesn't say some other things either. It says they'll be treated as if they were married, but it doesn't say that they're going to be husband and wife. The tenants by the entirety law says you must be husband and wife. All right? So right now there's a flaw in the law that I expect will get changed the next time the legislature gets together. And they're going to change the tenants by the entirety section on the code and the statutes that'll say that tenants by the entirety are husband and wife or registered domestic partners. Okay? That's what they're going to need to change. But until then, it's unclear. Okay? Because right now it says husband and wife, and registered domestic partners are not husband and wife. Being a real estate lawyer, I'd like to be abundantly clear with what I do. So when some folks come in and say, well, I want the deed to say registered domestic partners, I'm like, that's great. We'll happily put that. Now let's address how you're going to own the property. Okay? Because that's what we need to do. You can't say tenants by the entirety because they're not husband and wife.
If they've been together over 7 years or something.
We don't have common law marriage in Oregon. We just don't have it.
Is that why we have with right of survivorship?
Well, you can do it in a will, which has always been available, or you can do an Erickson estate, which I'm going to talk about in a moment, which is what I paid you to mention a moment ago. In an Erickson estate, I don't want to talk about that. I want to finish the other part. The most creative way I've seen to take title as domestic partners is it would say to so-and-so as domestic partners, as tenants by the entirety if the law allows, and should the law not allow, then not as tenants in common, but with the right of survivorship. Yeah, got paid a lot for that one, didn't I? All right, because it made it really clear, sure they're domestic partners, and sure if husband and wife works, then great, but if it doesn't, then we still want to address the same thing. So we have this thing in Oregon called an Erickson estate, and it allows people who are not married to have a right of survivorship. Now, since the presumption is, since they're not married, they'd be tenants in common, and we don't want that because we want a right of survivorship, we have to say something different. So the operative language in the deed would be to so-and-so, not as tenants in common, okay? We just rebutted that presumption by saying not as that, but with a right of survivorship. That allows, should the one die, the other one still owns the whole. That's been around for a while. We did not need registered domestic partners to have that part of it. So that part's been available. And that's the way I'm suggesting registered domestic partners take title still until we fix the tenants by the entirety law. May not come up for you a lot, but to the extent it does, you'll know why you see that language. So that's an Erickson estate. So I've spent this whole time talking about all these fundamentals of what makes up ownership of property so that I could talk about deeds, okay? So that when you see that deed, you don't just see 16 or 17 squares, so that you can see all 30 of them. There are 4 types of deeds in Oregon, and there are only 4 types of deeds. They're all in the statutes, and they're called a statutory warranty deed, a statutory special warranty deed, a statutory bargain and sale deed, and a statutory quitclaim deed. Those are the only 4. Sometimes you'll see deeds that say trustee's deed, okay? There's no such thing as a trustee's deed. It's a deed, and it's going to be one of those 4. Sometimes you'll see personal representative's deed. No such thing. It's still going to be one of these 4 deeds. It doesn't matter what the top of the document says. It's only going to be one of those 4 statutory forms. Some years ago, the county clerks got a little too uppity in how they felt about the power that they had because they'd been given a list of documents that could be recorded. And they took the position that said, if it's not on this list, I won't record it. Anybody ever encountered that problem? Tried to record something that wasn't on the list? I see a few heads nodding, especially from the title folks. And it's a really bad idea. The list they have does not say it's an exclusive list. The first time I encountered it, I had an agreement. I had some sort of agreement. I don't know what it was called. The very nature of commercial transactions is we're doing unique and interesting things. We're creating stuff. We make stuff up as we go along. Hopefully it works, but we're making it up. That's what makes it so much fun to do. So I had this document that I needed to record, and I took it into the county recorder's office, and they said, nope, it's not on our list. We won't record it. You got to be kidding. Nope, it's not on the list. Won't record it. Show me the list. Looked on the list. Common documents you normally see. One of those was easement. Went back to my office, covered up the title of the document, put easement on there, took it back, and they recorded it. Didn't change anything else. Just called it an easement. I can't tell you how many documents I've recorded called an easement. There's no easement in there anywhere. Okay? None whatsoever. But the title it was otherwise going to be called wasn't on their list, and I didn't want to have to mess with it. So I called it an easement, and I recorded it. Because the title of the document doesn't matter even a little bit. I've seen people take a warranty deed and say, oh, I want it to be a special warranty deed. So they type special in front of it. You know what they did? They committed malpractice. Right? They did not create a special warranty deed. There's a bill that's going to be proposed in front of the next legislature to tell the county clerks that they can't restrict what we record, which is kind of even an overkill from what we need, but it's kind of a backlash deal. We're going to be able to record anything, whatever it is. It'll give us a little more work as a title insurance company to figure out what actually applies to a piece of property or not. It'll actually make the counties more money because they get recording fees for everything that's recorded, and they make money off of that, so it'll probably be to their benefit. When that law passes, I'm going to record a document called duck. Okay? Title, duck. All right? I don't know what it's going to be in the body, maybe an easement just to make it fun. But I'm going to call it a duck. And it's not because I went to University of Oregon, because I didn't. Boy, didn't the Beavers do well last night? Holy mackerel. Gotta love that. Even I watched that game. Anyway, I'm going to record a document called a duck. And the reason I'm going to do that is that whole thing about if it walks like a duck and it quacks like a duck and it looks like a duck, it must be a duck. All right? And I want to make the point that the title of the document doesn't matter. It's what's in the body of the document that does. I've drafted all kinds of agreements that somewhere in the body of the document has deed language. You know what it is? It's an agreement and it's a deed, because I had deed language in it. It's the language in there that matters. So the first one I want to mention is a warranty deed. These are created by statute. I was very clear when I mentioned their statutory warranty deed. It's created by statute. The statute says what the words are. When we use words in a statute, the idea is they're strictly construed. We apply every word as if it has its own meaning, which is why you often see, you'll say, someone shall do this and they shall do that. We don't use the word will do this or won't do that, okay? We use shall all the time, because if we use, the way statutory construction works is, if you use shall in one place and will in another, they're different words. You must have meant something different. Well, there isn't any difference. So we make sure that we use the same word all the time if we want to have the same meaning. If we use different words, then we must have meant something different. So, in a warranty deed, the operative language is conveys and warrants. All right? I don't care what the top of the document says. If it says duck, ignore that and go down and see what kind of deed it is. If it's a warranty deed, it will say conveys and warrants. So Jim conveys and warrants to Jane. Okay? I've now used a warranty deed to transfer my property to Jane. Two words, different meanings. Conveys means I have transferred the entire bundle of sticks to Jane, all of them. Every stick I own has now gone to her. The sticks that have been given to other people are still out there because I can't convey those. But every stick in the bundle that I have, by the word conveys, means it transferred it to her. If I was ever going to change the statute just to make it more fun, I'd say in the statute, conveys means transfers the whole bundle of sticks. And all of you would completely understand what that meant. Warrants is a different word, so it has its own meaning as well. It has nothing to do with the transfer of the sticks. What it says is that I promised to Jane that she now has all the sticks. And if I didn't give her all the sticks, she can come back and sue me. That's what warrants means, which is why we have a list of exceptions to title on a warranty deed. Okay? You take all the sticks that you found in the prelim. You know when you get a preliminary title report, next time you get the prelim, you're going to notice, you're going to go, it's going to have 1 through 13. All those things are just sticks that have been given to other people. That's all a preliminary title report is. It's just a list of sticks that other people own. So we list out in the warranty deed what the exceptions to title are that have been given to other people so that Jane can't sue me for those. Okay? So that's what a warranty deed does. It transfers the property free of all the encumbrances except those that are listed. It's far and away the most commonly used form of deed, right? I presume it's the one you see in almost all of your transactions. In commercial transactions, we almost never use warranty deeds. The most commonly used form of deed in a commercial transaction is a special warranty deed or a bargain and sale deed. So, under special warranty deed, again, it's not the title. I've seen a broker, honestly, once type special in front of warranty deed and think they'd created one. Okay, it didn't work. The operative language in a special warranty deed is conveys and specially warrants. So Jim conveys and specially warrants to Jane his property. Conveys, same word as last time, must mean the same thing. Same word, same meaning. It means I conveyed all the sticks I owned to Jane. Okay? Specially warrants, that's different than warrants, so it must mean something different. I know I'm making it sound simplistic, but that's really how it works. It means something different. What it means is that I am only warranting to Jane the sticks that were given away during my ownership of the property. What the previous owners did with the property, that's their business. I'm not responsible for what they did. I only tell her about the roadway easement I gave to the neighbor. All right? If the previous owners gave a roadway easement to the neighbor and I don't tell Jane about it, that's too bad. She can't sue me for it because I didn't warrant about those. I only warranted about what I did. The reason why those are commonly used in commercial transactions, I think, makes perfect sense. Why should I be responsible for what the previous owner did on the property? It's not my deal. I didn't do it. I should be responsible for what I did. So that's why we use those in commercial transactions. And when they say, but what do we do about these other sticks? Then you say, well, you're getting title insurance. Okay? And in fact, most sellers are not nearly as big as title insurance companies. So who do you want to sue anyway? Do you want to sue the previous owner who's moved on to whatever or doesn't have much? Or in a commercial transaction, it was a single purpose entity that after the transaction, we dissolve and it's gone. You're not going to sue them anyway. So you have title insurance that covers for the previous ownerships of the property.
Was that brought about maybe to try to protect themselves against any DEQ contamination or something that was found?
No, because it doesn't help with that at all.
It doesn't?
No. Not to mention the fact that special warranty deeds have been around a lot longer than we've had environmental regulations. So, no, it doesn't have anything to do with that. You're still going to be responsible for having spilled.
Yeah, I know you are. I just wondered if it was, in effect, trying to do something about it.
No, because it's only warranting about title issues. Okay, that's all that, about the sticks that have been given away.
Other sticks show up on the preliminary?
They would, but see, environmental problems aren't sticks.
No, I mean as far as the specialty warranty.
Oh, on a special warranty deed, sure. If you get a preliminary title report, it's going to show all the sticks anyway. But they're not going to warrant about those because they're not going to be responsible. It's one thing to say you've got a title policy and so you can sue the title insurance company. It's another thing to say, because you don't on a warranty deed, you're not saying you can only sue them. You can still sue the seller as well. And it's a way for the seller to say you can't sue me for these other things that have happened. So the next type of deed that is also used in in commercial transactions is a bargain and sale deed. The operative language in a bargain and sale deed is conveys. Okay, that's it. It's the only word. I see a lot of deeds out of California that are just called deed or grant deed or whatever, and the word they use is convey in that. Well, it's a bargain and sale deed. Okay, doesn't matter what they call it across the top. If they use it in Oregon, if it just says convey, it's just a bargain and sale deed. So we all know what conveys does. Conveys transfers the whole bundle of sticks. Okay? So it's a perfectly good deed. It transferred all the interest I owned in that property to Jane. All the sticks went to her. The difference is I'm not making any warranties at all. There's no list of exceptions to title to put on that deed because I haven't made any representations about the condition of the title. The reason why we use that in commercial transactions, again, is we say, you're getting title insurance anyway, and our entity's going to be gone the day after closing. So there's nobody for you to sue anyway. Has no warranties whatsoever. The fourth and final form of deed is a quitclaim deed. The operative language in a quitclaim deed is releases and quitclaims. Didn't see the word conveys in there anywhere, did you? So it must mean something different. Under a quitclaim deed, it transfers the current interest of the owner, only what I have now.
If I have anything.
Well, same with, no, it transfers everything I've got, just like a bargain and sale deed did. Bargain and sale deed didn't say, I'm transferring you this and I own it. It just says, I'm transferring you all the sticks I own. Same thing that it actually does a little bit more because it's transferring all the sticks. A quitclaim deed, and what you just mentioned is what a lot of people seem to think. It's, if I happen to own it. If I'm going to sell the Brooklyn Bridge, I'm going to use a quitclaim deed. In Oregon, you may as well use a bargain and sale deed. Because what? They're going to sue you if you didn't transfer it to them? You made no warranties. Okay? Does the same thing in that respect. But a quitclaim deed only transfers the current interest of the grantor. One of those sticks in that bundle is called an after-acquired title stick. Okay? The after-acquired title stick says, should I later acquire an interest in the property, I'm also going to give it to you. All right? So let's say that you had a loan on the property, so you granted a trust deed. And I use a wrapped trust deed to sell my property to Jane. When my lender reconveys that property because the loan's paid off, they transfer it to me. Okay? They don't transfer it to Jane. They don't even know who she is, or they don't know she's there. And certainly the terms of my loan with my lender say they reconvey it to me. The after-acquired title stick that I gave to Jane would say that that title hits me and flows straight through to Jane because she gets whatever after-acquired title I had. Under a quitclaim deed, you don't transfer that stick. Doesn't make any difference to any of you. Doesn't ever matter. I see people using quitclaim deeds all the time, and my question to them is, did you intend to retain the after-acquired title stick? And they say, the what? I intended to sell whatever I had. Then why didn't you use a bargain and sale deed? The idea here is for you to understand that if you are choosing a deed form, choose it based on what it actually does. Use a quitclaim deed if you intend to retain the after-acquired title stick, which is never going to be the case. So anytime you use a quitclaim deed, think about that. And you go, gosh, I probably meant to use a bargain and sale deed, didn't I? Because I'm not trying to keep a stick. Most people use quitclaim deeds and they meant to use a bargain and sale deed. But somewhere along the way, somebody said, if you're going to sell something and it says, I'm going to sell you this if I happen to own any of it. Okay? And they said, use a quitclaim deed. I see malpractice all the time by lawyers who use quitclaim deeds when they didn't intend to. They intended to use a bargain and sale deed.
Does a quitclaim deed preclude all the parties on the quitclaim deed from ever owning interest back in the property? Again,
I'm not understanding your question.
if
You
somebody...
mean the grantors? Does it prevent the grantors? No, in fact, they retained the after-acquired title stick, so they could own it again. If my lender, if I transferred my property to Jane under that, under a wrapped trust deed, and my lender on that first loan conveys to me, okay, I gave her a quitclaim deed, I now have an interest in that property. I actually have a lien on that property, because remember, this is a lien theory state, right? The lender had a lien. They transferred that lien to me. I now have a lien on the property Jane owns because I didn't give her the after-acquired title stick. Again, that was not what was intended. So what I'm suggesting to you is only use a quitclaim deed if you intend to keep that stick. And I know none of you ever will intend it. So I don't expect to see any quitclaim deeds come through your offices anymore because there's just no reason for it. But that's what it does. It's not a stick that people want to use. In the state of Washington, we have different deed forms. We don't have a special warranty deed. We don't have one we call a special warranty deed. We actually call that one a bargain and sale deed. So we don't have the equivalent of an Oregon bargain and sale deed. So what we do is we use a quitclaim deed, and we say we release and quitclaim this property to the buyer, and we transfer them the after-acquired title. That's what we actually type into Washington quitclaim deeds to make it look like an Oregon bargain and sale deed. Because again, nobody intends to keep that stick.
Well,
But
I've come across before where children had been purchasing from a parent a property, and the lender said, no, you have to get them out of there. And they've done a quitclaim deed.
Sure.
But what if the children want to purchase that property again? I mean, really purchase the property?
That would be fine. You can still purchase the property again, even with a quitclaim deed. I mean, even if you use a bargain and sale deed, because that's a little different than just the after acquired title thing. So it would still work just fine. Quitclaim deeds should almost never be used. When I use them, mostly it's to terminate easements. Okay, that's a really common thing because I'm not transferring the whole bundle of sticks. I'm transferring the stick I do own, and the stick I own is an easement. So it's a great way to terminate an easement. Or a duck. Or a lease. And I don't think it's a good way to do it, but I've seen people terminate leases by using a quitclaim deed. Because you know what it did? It transferred that stick. So it worked. I'd rather see people use a lease termination agreement, which makes it abundantly clear. Plus you get to use more words and all that kind of thing.
But if it's like a lease purchase to buy kind of thing.
Quitclaim
that
deed?
work?
Yeah. Yeah, that works. See, those are instances where you might want to, it's usually when you're terminating something is the appropriate time to use a quitclaim deed. Otherwise, I think you normally want to use a bargain and sale deed. So those are the 4 types of deeds. As I mentioned before, lawyers bill by the hour. We bill by the 6-minute increment. And when I look at my watch, we're within 6 minutes of the top of the hour. So by golly, that makes it noon. So does anybody have any questions? And I'm happy to answer questions right now, if you have any more, and I'll stick around for a few more minutes, and I'll answer some more questions.